killings.
Okay, welcome back, boy. That is riveting, and I could not have two better guests than the two I'm going to bring on this Columbus Day, this holiday. And first, let me start with Matthew Mangino. He's out of Pennsylvania, at Matthew T. Mangino for his Twitter handle. He's a former prosecutor, criminal defense attorney, former parole board member, wrote the book The Executioner's Toll in 2010. He's a columnist, and he is featured on many different kinds of writings and shows. Matt, how are you? Welcome to the show.
Great. Thanks for having me.
Okay. And, of course, my man, Gene Rossi out there. Boy, you guys know, it's at Rossi4VA. That's the Twitter handle. 27 years, 100 in the Department of Justice, 110 trials, 90 jury trials. That's an amazing, whopping amount of trials. He's handled everything from police corruption, narcotics. He's been a chief of his unit, multiple law enforcement awards. And my favorite, he's what I call my hashtag 4041. If you ever see my Twitter at Bianchi ESQ, because he shot a 40-point game and a 41-point game when he's in high school. Welcome back, Gene.
Happy Columbus Day.
Yeah, happy. They got the three paisans, here, right? So Mangino, Bianchi, and Rossi. Yes, on this Columbus Day. Guys, this trial was unbelievable, the Van Dyke case. We just watched the verdict, and what I want to throw to, and I love to do when we have replay day, is we really get to educate our audience, especially those that are in the chat room all the time and wanting to know the little special nuances and things that you would not normally see unless they had pros like you guys. So let me start with you, Matt, with the anxiety of a verdict being read, waiting for that jury to come back, let you know what your life is. And on this case, wasn't he odd in the way that the verdict was coming in through this whole trial? Kind of obtuse, numb, maybe medicated? What are your thoughts, Matt?
Well, there's no question that the anxiety level is extremely high when you're waiting for a verdict. And certainly the time where you're just, sitting either in your office or in the lawyer's lounge waiting for a verdict, while the jury deliberates, but that anxiety level really peaks when you walk into the courtroom and you're looking at that jury and you're looking at that judge and you're waiting for a decision. Certainly Jason Van Dyke was subdued. I think his counsel probably told him to be subdued and to show no emotion in this situation. But certainly there was a lot on the line, and when he heard that verdict, he certainly wasn't pleased. But there, like you said, it was kind of a very subdued Jason Van Dyke.
Yeah, and Gene, it's amazing to me that, the verdict comes in, and when there's a conviction, there they go out in handcuffs because they're no longer presumed innocent. And there you see a police officer escorting a former police officer to the big house, and that's got to be a frightening thing because being a cop, especially on a case like this, going to the county jail before you actually get sentenced to state prison is not a good place to be. What are your thoughts?
Are you coming to me, Bob?
Yes,
because I can barely hear.
Yeah. What are your thoughts, Gene, about the verdict?
I can't hear.
Okay. Well, we'll work on that. But Matt and Gene, while we're working on Gene's audio, we got you, Gene. We'll be with you in a second. Listen, this case came down, in my opinion, very heavily on a very substantial piece of evidence that was introduced that didn't have to be. And what I mean by that is the testimony of Jason Van Dyke himself. As you guys know who watch the Law and Crime Network, and our chatters are in that chat room, you know what my guy who taught me, who was the best in the business, always said, as a prosecutor, jurors love to convict out of the mouth of the defendant more than any other piece of evidence. Let's take a look at some of that testimony while we get Gene's mic fixed. Okay, so that was the testimony of the defendant, Van Dyke. And I have the two guests here. I think, Gene, you can hear me now. Gene, you there? Awesome. Okay, well, welcome. So let's go to this, Gene. Now, you've been following this trial. We've been on together a couple of times. It is a really killer move to put a defendant on the stand. I have literally won cases as a prosecutor that were very challenging, murder cases in particular, and I can think of 3 occasions where the defendant's testimony sealed their fate on cross-examination. You would have expected this officer would have been very prepared, but I don't believe he was, and the jurors said he came off as being rehearsed. What are your thoughts?
Bob, my thoughts are this. If a witness is not prepared properly, especially a defendant, and I would have prepared him over 4 days, I would have been nasty, mean. I would have gone through every hole in his testimony. If they think he's not prepared and he's rehearsed, and you have to get that balance, then it's devastating. And it could be one or two little lies. It could be one or two big lies. But if they sense that that defendant is lying, he's guilty.
Right. Now, guys, I'm going to throw something to each one of you that I want you to answer. And I know it's a really hard question, so it's a little bit of an unfair one. But we'll probably never know this, at least until the appeal comes. But do you think this was a case where the defense attorney suggested to the client that they take the witness stand, or that he suggested that he not take the witness stand, but the client insisted? Of course, always understanding the lawyer can only give advice. It's up to the client as to what decision to make. Matt, what do you think?
Well, as you said, it's up to the defendant. It's up to the client whether he wants to testify. It's always a risk to testify. The question is, was he thoroughly prepared for his testimony? He certainly seemed nervous. He didn't come off very well, and the jurors who spoke to the media after the trial basically said it was a mistake. I think you have to do what your client wants to do, but it's always a risk, and it can come back to bite you, like I think it did in this particular case.
Well, listen, when a client takes the stand, Gene, there are two pieces to it as I see it. One is a likability factor, or, connection with the jury, which is very, very important. And, of course, the second thing is, can they provide substantive evidence that will help themselves out? One, I found him to be obtuse and unlikable, not making a connection. And two, the defense attorney had to have let him know, you will be cross-examined in this story that you were backpedaling and he was making moves towards you, which is completely belied by the tape. You need to have an answer for that. And it just didn't seem like he did. Is it possible the lawyer didn't prepare him? I find that hard to believe.
It sounds like, Bob, that he wasn't prepared for that, because that is like the elephant in the room. The video is different than what he said after the moments after the murder. Now, I didn't hear my colleagues' comments about whether the defendant and the defense attorney agreed. I think in this case, they both agreed that he should take the stand. If they had prepared him properly, the jury wanted him to take the stand, even though they don't have the burden of proof. They needed to hear from him. And I would have stressed, if I were the defense attorney, that you have to give what was in your brain before you approached this defendant and you saw him. What was your state of mind? And it could have gone from first degree to second degree, maybe to manslaughter or just the aggravated battery, if he had done a good job.
Gene, you bring up a point that I'm going to take up with you, and it's with one word, or two words, the brain. I want to talk about that a little bit on the other end and have an alternative defense theory that I want to see if you guys would have thought would have played better to the jury. It may have actually been more accurate as to what occurred here. But let's listen to a little bit more of Van Dyke's testimony. And, guys, get in the chat room in the Law&Crime Network. It's Columbus Day. Many of you are off, so why not get a cup of coffee and hang out in the chat room and try to answer some of your questions. We'll be right back. Okay, welcome back. We are in the Van Dyke trial. I got my great guests, Matt Mangino and my good friend Gene Rossi here. I think we're all hooked up. Our mics are operating. Our earpieces are ready to rock and roll. So, guys, Gene, you were last making a point about his brain. Observation. In many of the police officers' shootings that I have investigated, I have found that many times they don't even really know exactly what went down when they fired their shots. They're in such a panic. And in this particular case, do you think that he was testifying more because of the video? And what I mean by that is, wasn't there a possibility that he was armed, Laquan, or he could have been perceived he was armed? He's walking down the street with the knife, and then he moves towards his waistband. There was another case recently where a cop was acquitted for that very same thing. I'm not sure, Gene, if you can hear me, but let's throw that to Matt first.
Okay. I can.
Well, yeah, the problem that Jason Van Dyke has is that he had to go in and testify to the jury and basically tell them that what you saw isn't really happened. And that's a tough sell. He shoots 16 shots into Laquan McDonald. He says he was moving toward him. He said he had moved his arm in a menacing way. The video didn't show that. I don't care how long you prepare or how intense your preparation is. You can't undo what the jurors are going to see. you can't tell him that isn't what happened. What you're watching isn't what happened that night. And that's what he tried to do, and it was unsuccessful, obviously.
Well, Gene, let's break down what Matt's saying a little bit here. Here you see a video of him right there. This is what I'm talking about. If you take a look at your screen, he starts to veer off to the right. He's swinging that knife in his one hand. He's got his left arm down by his waistband. And let's say the officer unreasonably believed at that point in time that he had a violent encounter with the truck stop, had a violent encounter with the police officer, sliced the tire, isn't listening to officer commands, it's ratcheting up, and from his vantage point, his perception, when Laquan was moving away, he reached towards that waistband and he reasonably perceived he may have had a gun. I mean, that to me is a lot better, Gene Rossi, than going in and saying to the jury, don't believe your lying eyes.
Well, what I would have done is, first off, his demeanor on the stand, I don't know if he can't help this, but he came across as a person who was just stubborn. That's all. That's the impression I got. He came across as a police officer who was stubborn. Putting that aside, if I had done a direct exam of this officer, I would have gone through slide by slide the parts of the video that were bad for him. And here's why. I firmly believe in a criminal trial, whether you're a prosecutor or the defense, and we could talk about the Jessica Chambers trial, there were holes in the prosecution's case. You have to embrace it. You have to embrace it and try to make lemonade out of lemons. I've seen it done successfully against me. When I was a prosecutor and I thought I had a really good fact, I was amazed that some defense attorneys embraced that fact and gave a viable explanation. And here's his viable explanation. He is looking at a deranged man. He is looking at a monster. In his brain, he's facing a monster who's got a knife and probably has a gun in his head. So when he shot him the first time, he thought he was going to pull out a gun. When he got on the ground, he thought he was going to pull out the gun. He doesn't have to prove it beyond a reasonable doubt. He has to raise a reasonable doubt. That direct was so flat, so unemotional. He had tears, but there was no emotion when the tears came down his cheek. It really was a bizarre direct exam in my book.
Yeah, well, Gene, you're making awesome points, and this is what I'm kind of saying about investigative bias, or if you will, the brain, that he may look at the tape and I'd be trying to cater his testimony to the tape as opposed to what was actually going in his head. I thought for certain, just having reviewed it, that there was a possibility that they were going to argue that he could have been armed with a gun. I'm really shocked it didn't really get developed at all, if at all, in this case. But let's go to listen to a little bit more of Jason Van Dyke's testimony. We'll be back with our two great guests on the other end. Well, welcome back to the Law and Crime Network. We are covering the Van Dyke trial, and we have Matt Mangino and my friend Gene Rossi with me. They're going to be helping me carry this through from the 12 to 3 p.m. hour that I'll be hosting the show. But let's go to the verdict one more time, take a look at that, and I'll be back with Matt and Gene on the other end. Okay, that's the verdict, and that is that, as they say. He was escorted out of court. Wasn't handcuffed, but he was actually escorted. He actually put his arms behind him, and afterwards he lost his presumption of innocence, so he no longer was entitled to his bail. He was remanded to jail. So listen, Matt, I have one question for you, and Gene. We'll start with you, Gene, on this one. So the Van Dyke's up there right now. Here's what I heard. The prosecutor, why'd you shoot him? I mean, come on. This is the softball. I would never even ask that question as a prosecutor, but I guess maybe she sent something. Why'd you shoot him? What? Can you please repeat the question? What do you mean? Let's just start with that. Gene, what's happening?
Okay, Zen.
It's serenity now.
Let me tell you this. Any prosecutor who ever asks a witness, I mean the defendant, why you did something, that could be a soliloquy that would make Hamlet pea green with envy. He should have spoken, and this goes to prep. I would have prepped the defendant, Officer Van Dyke, if the prosecutor gives you a chance for an open-ended answer. You run through that like Gale Sayers ran for a touchdown in the 1960s. We're in Chicago.
Or like Gene Rossi's running to the hoop in a 40-41 game.
You goddamn right. Because I couldn't, Bob, I went like this. and if you show the clip back, after she asked that, why did you shoot him, she put her two arms behind her back like she was handcuffed because she dodged a bullet, no pun intended. He could have gone on for 10 minutes.
This is why, Gene, I love having a guy like you and Matt on, because you can't, guys, that what Gene is saying, I agree with, was a poor prosecutor's question, opened the door to the rehearsed answer to go through like a bomb, like Gene going to the hoop. But Matt, let me ask you, later on, she's saying another bad set of questioning, with all due respect, they won the case, I get it, but, well, you said in your statement, did you not? And of course, he's now deflecting. You got a bad question. You got a bad answer. Bad defendant testifying. I don't remember what I said to the detective that night. I was in shock. The question the prosecutor should be asking is, you've been here for the whole trial. Are you telling me you didn't read your statement that you gave to the officer? Are you telling me you didn't hear it when it was being introduced in his court? Are you telling this jury under oath that you have not even looked at? I'm not asking you about that day. I'm asking you about what you heard today when you took the stand. You never looked at that? Matt, what do you think?
Well, there's no question. I mean, that was a very poor performance. I mean, anytime you have your witness saying, I don't recall what was earlier said during the course of the trial, is never a good thing. And here you have Jason Van Dyke basically contradicting what his own expert testified to during the course of the trial, and also contradicting exactly what the jurors watched. You know, so it's not as though, you know, this is a matter of, well, here's one version and here's another. The jurors watched this videotape, and he's providing testimony that's contrary to what they watched. And then he has an expert who puts together an animation who he says, well, that wasn't my perspective exactly.
Oh my God, Matt, I was going to hit that. There's just too much for guys like us to be breaking this all down. You're right. Don't believe your lying eyes. And by the way, don't believe your expert. That should my expert, rather. And the prosecutor's using the defense's reconstruction expert, and he's disputing it. Listen, Gene, you know me well enough. I need to put the coffee down. I need to get into put the fan on and calm down a little bit. Let's look at a little more Van Dyke testimony. I don't know what the producers have queued up for me, but I have a funny suspicion I'm going to get agitated again. Welcome back. That's Jason Van Dyke. Gene, let's just real quick get to this. We talked about likability and facts. And here, how about some of these statements? I'm trying to answer your question, Miss. Hesitating all over with things that are very basic, disputing over and over this idea of what the tape is showing. And I thought another prosecutorial mistake was when she says, was it a slip, Gene? When the prosecutor says, you're trained to shoot center mass, not at the knife. His great answer would have been, yes, I'm there to shoot to neutralize the threat. But instead, they're getting into an idea of whether he was trying to shoot a knife out of a hand. What do you think?
What is very sad is this officer looks guilty. He seems to be very uncomfortable being questioned by a female prosecutor. That's one. His answers were a little sarcastic. But when he's looking at that video, the demeanor on him is like he is watching the ticket to prison when he's looking at that video. I got to go back to, I hope the defense attorneys sort of mooted his testimony before they put him on the stand, because his demeanor and his body language were utterly awful. And the prosecutor, there were a couple good questions, but you're right, she still has this tendency not to go for the jugular and ask leading questions and not WHY. And you know, right.
Gene, I'm sorry to cut you off. Matt, we're going to get to you on the other end. We're going to go to a break, and we're going to come back with more Law and Crime with my two great guests. This is the Jason Van Dyke trial. No better two guys to break down what happened. Second-degree conviction for murder. We'll be back. Welcome back. We are covering the Van Dyke trial today. So Matt and Gene, Matt, let me go to you real quick. What do you think about this whole, again, getting back to it, as we're listening to more testimony unfolding here, How could the defense lawyer have not beat him over the head with a bat not to testify, knowing the demeanor, the lack of likability, the obtuseness of his testimony, as well as the contradictions that were obviously going to come out? What am I missing here?
Well, the testimony is amazing. I mean, it's like that old country song, that's my story and I'm going to stick to it. He doesn't, regardless of what he's facing, he's going to tell it his way, and his way is not the good way. Certainly he's left a lot of holes in his story. He's not a likable witness. He doesn't come across as though he's being truthful or forthcoming. I mean, it's a train wreck. His testimony is a train wreck, and you don't have to be a lawyer to understand that. And then the jurors come out and said, hey, his testifying was a mistake.
Right. Gene, one of the things I also note is, let's talk about what they could have done here. They have experts that are testifying, experts that spoke to him. In fact, the prosecutor's now cross-examining him on statements that he made to his own expert. I think I would have preferred to get his defense out through the experts, get his statements out through the experts, as opposed to putting a guy like us on the stand. Agree or disagree?
I totally agree, and especially given his poor performance. I gotta make a suggestion. It's probably too late, of course. I would have gone back and watched the video of the Rodney King trial in Simi Valley, because the four defense attorneys, or the four officers and their defense attorneys, they put on a pretty good case. You can question whether the verdict was just, but what they did, and I remember this vividly, those officers were not warm and fuzzy, not all of them, maybe one. They were sort of like Van Dyke. But what they did is they went through the video that wasn't very complimentary, and they made lemonade out of lemons and brought out the emotion, the what's in that person, that defendant's brain during each segment of that film. They didn't do that. They didn't do that.
Right. Well, Gene, to the point, though, just so our audience understands, when you have an expert witness, that witness is allowed to testify about opinion, that which is above the average knowledge of a juror. And if they're relying on facts that are typically relied upon by experts in that field, it's hearsay. It comes out to the credibility and believability of the report, but not as substantive evidence. But, Matt, you would agree with me, nevertheless, the defendant's defense is coming out through their experts, yes?
Well, it is, but their defendant is contradicting their experts, and that's problematic.
Yeah, so I think we're all on the same page with this. It's just confounding because you would be, like Gene had indicated earlier, I would have been beating this guy up. I would have been doing the nice guy routine. I would have been doing the hard guy routine. I would have brought people coming in that hit people over the head with bats and pipes in a courtroom. You would have to know that this guy not only is going to contradict the video, but contradict his very own expert. Guys, awesome commentary. I love having you on. Let's go to the use of force expert for the defense and get a little bit of a feel about how expert testimony can be very powerful in a case if utilized properly. And as my two great guests are also noting, so long as you don't take the stand to contradict what it was they said. Okay, so we're in the Jason Van Dyke trial, and what we're listening to right there is the defense use of force expert. Hey, Matt, overall, what did you think? This is direct examination. What did you think about the direct examination of the defense lawyer and where they're going with this?
Well, I mean, he laid out, his qualifications. He lays out exactly what he reviewed in making his or putting together his opinion. I thought it was interesting that he asked him if he had ever, given an unfavorable opinion. That would really be a malpractice if he came into court and rendered an unfavorable opinion on behalf of a client. But I think that he's trying to slowly and methodically show that, hey, maybe not everything that you see in the video is exactly what the officer's experiencing at the time. And I think that's what Jason Van Dyke had a difficult time conveying to the jury. Hey, you saw a video, but that's really not what's going through my mind. That's really not what I'm seeing under this intense pressure with an armed suspect and me with my gun pointed at him.
Yeah, and we're looking at that video again, and I keep getting back to the same point where what's going through the officer's mind, what a reasonable officer would do under the circumstances is what's relevant, and sometimes video can be deceiving from that vantage point. Gene, he's basically saying he looked at everything that led up to the confrontation, so this gets into all the character evidence, if you will, of the victim and what the victim was doing. The confrontation, the refusal to submit to officer commands, the weapon, he makes a polished approach. Thoughts about, if any, that, and the fact that he says the first volley he found no problem with, but he needed further information with regard to the second volley when he was on the ground. I think that that's a reasonable thing for an expert to ask for, and part of that was speaking to the defendant. Thoughts?
I thought he was excellent. And as a matter of fact, I thought he was so excellent, I probably would have recommended that Jason Van Dyke not go near the witness stand. But I do want to pick a little bit on the direct exam of their expert. When I trained all my prosecutors, I always talked about onions. You want to peel that onion for the jury. And when he said that first volley was clearly justified, I would peel that onion. I would have played clips of the first volley and stopped the film and say, now, why was that shot justified? Tell me why. And he could get into the prologue, what he was like before that incident. He could get into the millisecond before the shot. And he brought up an excellent point, and this is where the onion comes in. What about the angle of that camera that is deceiving? Play the film and have him describe on that camera what may be deceiving. So my one critique of the direct by the defense is they didn't peel that onion to the benefit of Jason Van Dyke.
Well, listen, you are at the Law&Crime Network. We are at the Jason Van Dyke trial rewrite, if you will. We're talking lemons. We're talking onions on this Columbus Day with two awesome experts. And only through these great analogies and through these pros can we really break the behind-the-scenes thing down. Gene, Rossi, I agree with that. This case could have been presented differently. We'll come back on the other end of this expert continuing to ask the question, if we did it kind of like Gene and Matt are saying, could have it made a difference? All right, welcome back to Law&Crime. That is cross-examination by the prosecutor of the defense use of force expert. We quibbled over about an inch of a blade and the standard questions about you paid for your services. I'm curious, in your guys' jurisdictions, you got Pennsylvania, Virginia, and Jersey. Is that a proper line of questioning? And or if it is, does the judge give a limiting instruction explaining that experts are allowed to be paid, just like the state's experts who are paid by the taxpayers are paid? Let's start with you, Matt.
Well, yes, in Pennsylvania, that is an appropriate point of inquiry. The judge can give an instruction that there's nothing wrong with someone being paid for their services. But obviously, what the prosecution is trying to show, at least to the jurors, whether fairly or unfairly, that there's a certain amount of bias that this witness has because they've been paid $12,000 and will be paid additional fees for their work.
Gene, what about by your way? The same thing there? And or do you find this to be an effective line of cross-examination?
The cross-examination of the fee is always unremarkable to me. In Virginia, federal court in Virginia, we don't have a specific instruction on fees to an expert. And what a good prosecutor or a good direct exam should include is you want to front and ask the witness on your direct, how much are we paying you? What are you getting an hour? So I hope that on direct exam they brought that out. But if it was brought out on direct, I wouldn't spend more than a half a second on that and cross. And I did a comment on, I like style. You're presenting a case. I don't like a person who is cross-examining to be looking at the floor and walking when they're asking the question. You look at that witness, you look at them and you state your question and you wait for their answer. If you want to move before your question. That's just style.
Right. Now, Matt, that's a great points, Gene. Also, in another part of this, the prosecutor picks up a knife with the use of force expert. We may get to that clip a little bit later. And in the confines of the gentility of the courtroom, stands there with the knife and says, "Do you mean to tell me this would be a threat to you?" Well, we all know about closing the gap. That's another one of those things where I think the prosecutor made a mistake, but the defense didn't capitalize on it. What do you think?
Well, yeah, I think you're right. I mean, what's important in a case like this is that the defendant and defendant's counsel is on their toes every second, especially with regard to this cross-examination, and is ready to either rehabilitate that cross-examination or object when appropriate, or capitalize on what may be perceived as an error by the prosecution in their questioning. There is no time in a trial to relax or to be taking notes or thinking of what you might be doing, later with another witness. You have to be on your toes at every moment and capitalize on every potential error.
Absolutely. You try the case from your heart. You got to know it inside and out. I rarely even look at a note by the end of a trial. I just know it so well. Listen, you guys are awesome guests. This is a Law&Crime Network gavel-to-gavel coverage. It's Columbus Day. We're covering this case. We're going to be back with the defense expert with more information. Okay, welcome back. We are doing a trial recap in the Jason Van Dyke case where Laquan McDonald, he was convicted, Jason Van Dyke, last week. So we got two great guests with us, and we've been breaking this case down. We've listened to one expert witness that the defense had, and that was a use of force expert. But there was also a defense psychologist. All excellent experts to get the defendant's story out without him having to testify. We'll be back on the other end of this testimony. Okay, welcome back. So there is Dr. Lawrence Miller, another defense expert witness allowed to offer his opinion. And you saw that chart up there, the deadly force chart about their encounters, psychological encounters, stress. This is kind of very similar to what I was talking about before, Matt, about the idea that a lot of times in the cases that I've investigated, the cops cannot give you a complete accounting of everything that went on. Quite to the contrary of that, they're under stress. And he is bringing out about rumination, second guessing, and maybe trying to fill in the blanks. Then they're looking at the tape afterwards. And I think that this could be a partial reason why this guy's bombing on the witness stand. What are your thoughts? I mean, the defendant bombing.
His example was very good, so the jurors could relate. He also talked about the same kind of manifestations after an automobile accident, a crash in which maybe your life flashed before your eyes, and so that gave the jurors an opportunity to put themselves in the place of the defendant, even though they've never been in a gunfight or have ever discharged a firearm at an individual. So I thought that was important, and I think that had Jason Van Dyke listened carefully to his own expert in this case, instead of saying, I don't recall or I don't understand the question, or could you repeat the question? If it would have been, hey, it was such a whirlwind after that. I mean, I was just trying to put all my thoughts together. I talked to a lot of people and I gave a lot of statements, but I'm not exactly clear on what exactly I said. And, give me the benefit of the doubt here, essentially, to the jury. I don't recall because it was a terribly stressful situation, and you have an expert witness to support that.
Yeah, Gene, I've actually had one where the cop was so, I can't recall, I don't know, after shooting a guy at least 5 times, I believe it was, as I recall, that it almost seemed unbelievable, but it was on MVR and a body cam, and it was clear that the shooting was completely justified. It had to go to the grand jury. He was cleared. But, nevertheless, even to this day, the guy's like, I don't even remember a lot of the stuff I see on the videotape occurring. What do you think?
I thought Dr. Miller was a fantastic expert, and here's why. And I just thought of this, and it's embracing the bad facts. This expert said, Dr. Miller said, that he's basically overcome with adrenaline and emotion during the event, of course, and also after. And I would say to the jury in closing, there were 16 shots fired. We all know that. And something tragic happened. But if Jason Van Dyke was really engaged in a premeditated murder, and we're talking first degree, he would have taken out this sad victim with 2 or 3 shots, but he was so overcome with emotion and fear and self-defense that he felt, you may disagree with him, but in his mind, he felt that he needed 16 shots to get rid of reasonably and necessary what he thought was a threat. Would have it led to a hung jury? Maybe not, but at least it's something that you can argue. And if that had happened, if they kind of argued that with through the witness and in closing, they would not have needed Jason Van Dyke, who just did not read the transcripts or listen to his two prior experts.
And I'll just add to that, Gene, that who knows, I don't know exactly if this came out or not, but a 20-year veteran who was in a high crime task unit, I believe, probably has had a lot of scuffles in his career. I don't know if this came out. We'll find out from the producers. But nevertheless, never was involved in a deadly force encounter like this. So that even inures to even more of an idea that there was something that he clearly feared, and then you loop that into the idea that this guy was a knife and up to no good and attacked a police car. You may get that one juror on a hung jury. Excellent commentary. Let's go back to the expert. We'll talk more about it on the other end. Okay, that's the prosecutor cross-examining the defense's expert witness. Now, Gene's trained over 1,000 prosecutors. I've done a lot of training myself, and I know that he was jumping out of his seat a little bit there. I always say, Gene, and we've been on before, where you don't get into the cage with the bear that's an expert, and you certainly don't want the expert to become a professor in front of the jury. And he asked again that open-ended question, and he got taken to the hoop. What do you think?
Oh, my God. Bob, I had to do the Zen. When you are cross-examining an expert, you have to realize they are smarter than you, number one. And number two, when you start talking about psychometric tests and all that, you're going to lose the jury, and you're now arguing on their playing field. You got to stick to simple facts. I would have gone through that video and taken out some simple clips. And I would kind of, where's the psychometric test that tells you can shoot a man who's on the ground and he's half dead? You know? Where's the psychometric test that says you can shoot a man 16 times when they don't even have a gun?
Gene, I want to start. You just gave a primer to our chat room people and our people that watch this network that the way you cross an expert is through common sense, things that they didn't either review, testimony that's contradictory, previous reports that they've written. I know you're getting into your Zen mode, but using common sense. Matt, what do you think about that? And what about this issue? Educate our people about the cross-examination with respect to the lawyers being in the room when the psychologist was interviewing the defendant.
Well, I don't necessarily think that that's a big deal. The next question would be: Did they participate? Did they interrupt? Did they tell their client not to answer that question? Did they try to rehabilitate their client by saying, "Well, what did you really mean?" Sitting there or sitting in a room adjacent to it and listening to the interview, I don't think is a big deal. There would need to be more to it than that. And the other issue here is, as Gene has said, when you're dealing with an expert, you have to keep it simple. You have to keep it simple for the jury. Don't forget, your audience here is not people watching on the Law and Crime Network. It's the jury. And you got to make sure that your examination, whether it's a direct examination of an expert or a cross-examination of an expert, is simple, it's understandable, and the jury can take something from it.
Right. Real quick, guys, in 5 seconds or less, you could get real close with that kind of testimony about the lawyer in the room into getting into that right to remain silent. I could have saw something popping out there that could have been problematic. What do you think, Gene?
No, I think that was a fair question. Who was in the room?
You're a no.
And I think that was fair.
Okay. What do you think, Matt?
I'm a no, unless there's more extensive examination, and we find out that there was some intervention by counsel during the course of the interview.
Right, and my point on that is that it was the way it was asked. You got to worry that the witness could pop out with an answer that you didn't anticipate. It was just something that came into my head. I've seen things like that happen before. Thank you, guys. I appreciate that commentary. We're going to go to a break and come back with more Law and Crime on the Jason Van Dyke case. Okay, welcome back. That's Jason Van Dyke. He made a decision to testify. For those of you who may not have been with us earlier, Gene and Matt, we talked about this decision to testify. We were able to see the experts' clips, as I indicated before we threw to that shot there with the defendant. He's not testifying. I just asked one of the folks here on the Law&Crime Network, I mean, as this was going on, Gene, do you find him to be like a really weird guy, obtuse, something strange? Is he on medication? What's up with this guy?
Bob, when I first saw him testify, I did think he was on medication. I did. And he's drinking a lot of water. He's very emotional. I think he is guilty, but that is a pathetic performance by a person who's been an officer for 15, 20 years. Can I comment on the direct exam, please?
Please, go.
It goes back to the Onion. I saw his face. Okay. What about his face that alarmed you, Officer Van Dyke? Please describe to the jury in detail what about his face alarmed you. And have him testify for 4 or 5 minutes that he looked deranged. And I've seen that deranged look before. And I know of incidences where a person's high on PCP, and in my view, he was, and they'll do anything to kill anybody. I'm crumbling here. I'm doing the Zen. I'm crumbling.
I know, man. We need some incense burning and relaxing here with all this stuff. The great commentary, Matt. I'm going to get back to you on the other end. We're going to run to a break, and we'll come back with more Law and Crime and break down on the Jason Van Dyke trial on the other end. Hey, welcome back to Law and Crime Network. Matt, I know that you got to run and you've been patiently waiting. You did an awesome job. No doubt about the fact you were a former boss, like I was, of a prosecutor's agency. You were on the parole board. You're a criminal defense attorney. Really appreciate your commentary. Thanks for being on with us. Oh,
great. Thanks for having me. I learned a lot today myself from you and Gene.
Oh, I appreciate that. You have a good rest of your Columbus Day. Don't eat too many meatballs. Okay, guys, listen, you know I love the top crime stories. A lot of them are funny, but sometimes they're pretty serious, too. So let's take a look at that, and I'll come back on the other end and talk to Gene about one of those stories. Stay tuned.